Hi, welcome to 42nd session where we are talking about insolvency and bankruptcy code with a specific focus on liquidation of companies. So let's quickly do a recap as to what we have discussed in the previous session. We have so far understood what is the term insolvency, what we mean by bankruptcy, the meaning of the word liquidation. We have understood different types of liquidations, voluntary liquidation and also other kinds of liquidation. We have also understood winding up provisions under the Companies Act 2013 which are similar to liquidation. And then lastly we have understood what we mean by the term dissolution. And from today we are going to understand the legal provisions pertaining to liquidation as enshrined under the Insolvency and Bankruptcy Code. So let's quickly move. Firstly, Section 33, as I have told you before, that the entire concept of liquidation within the IBC begins from Section 33 of the Insolvency and Bankruptcy Code. So we are dwelling upon the very first section dealing with the liquidation, which talks about circumstances that lead to initiation of a liquidation. Under what circumstances liquidation can be initiated and under what circumstances it cannot be. So the moment we are saying under what circumstances liquidation can be initiated, we know that this is a standard methodology or circumstances where we can start liquidation. So let's see the first case. Whenever a rejection of resolution plan had occurred, why is a resolution plan rejected generally? The first and the primary reason for rejection of a resolution plan is where it is not in compliance with the provisions of the IBC, especially Section 30-31 of the IBC tell you what should be the contents of this resolution plan and what it cannot miss out. So the moment the provisions of this section are not met, the resolution plan gets rejected. When the resolution plan gets rejected, the very next step is the initiation of liquidation. So this is the first circumstance where liquidation can be initiated. The second one would be where COC, the COC is unhappy about any resolution plan and it feels that the proceeds which it is going to receive under any resolution plan are far below acceptable standards, and therefore it feels that rather than going for a resolution plan, it is better to actually do a liquidation, and hence COC decides to start a liquidation. In that case also it is absolutely permissible under Section 33 to initiate liquidation. So far number one is rejection of resolution plan, number two COC decides to go with the liquidation. Number three, the time given under IBC for presenting a resolution plan is completed and therefore there is no further waiting for resolution plan. In those circumstances also, the adjudicating authority may actually order liquidation of the company on an application made by the resolution professional. Last one is, this is slightly different from all other circumstances. Please see, in other circumstances what is happening is resolution plan was never made or never approved, and hence it was a very plain scenario for a liquidation. That is, resolution plan is rejected, COC decides resolution plan is not viable and hence liquidation is important. Third one, time given for submission of a resolution plan is completed and hence there is no more waiting period. But now the fourth one that you are looking at is very different. What is it? In this case, a resolution plan was already approved by the adjudicating authority in the past. The resolution plan is being implemented and at this point of a time, the resolution applicant, the successful applicant who took over the management of the company, is actually contravening the resolution plan that he has submitted himself. And hence, because the resolution plan is not being complied with, it is contravened, it can be a very fit scenario for initiation of a liquidation. So, as far as section 33 is concerned, it gives 4 circumstances under which liquidation can be initiated, and we are very clear about all those 4 circumstances now. The next question would be, okay, the order of liquidation is passed and liquidation is getting initiated. What are the effects of such initiation of liquidation? Which means, will there be a moratorium? Will there be any other benefits? Will there be any other special effects on the entire company? Is what we are trying to understand. This is enshrined again in section 33, which we are calling as effects of initiation of liquidation. First one, no one shall initiate any legal proceeding against the company which is under liquidation. That's the first restriction or the effect of liquidation plan. 2. Even the corporate debtor, which is a CD, cannot initiate any proceedings against anybody. So, it cannot fight a legal case on behalf of itself, nor can it actually defend itself in any legal case, because institution itself is not allowed. However, liquidator may initiate legal proceedings against any other debtor of the CD with the special permission of the adjudicatory authority. In our case, it is going to be NCLT. The order shall be deemed to be a notice of discharge. That means, the moment NCLT confirms that this is a fit case for liquidation and liquidate the CD, this order given by NCLT is a discharge notice to the employees and officers and workmen of the company. Very, very important. That means they need not again be given a separate letter of termination by the company, but the order given by NCLT itself will serve as a discharge notice, and their employment comes to an end with immediate effect on passing of such liquidation order. However, there is one exception to the entire scenario. The employees and the workmen may not be discharged if the business of the corporate debtor is continued during the liquidation process. Only then it is an exception. Otherwise, in all other cases, it is deemed that this is a notice of discharge for all the employees, workmen, and the officers of the company. To understand the circumstances which lead to initiation of liquidation, and also to understand the effect of liquidation, let's look at one important case, which is Jigar Tarun Kumar Bhatt, resolution professional of Eternal Motors Private Limited. In this case, the Ahmedabad Division Bench in court number 1 has dealt with certain matters under section 33. We'll see what they are. First, let's try to understand the facts of the case. Eternal Motor Private Limited filed for CIRP under section 10 of the Act. We are aware that section 10 is a provision which enables the CD itself to file insolvency proceedings. So when the CD files under section 10, what happens? The Honorable NCLT passed orders for CIRP. The RP made several public announcements and issued RFRP. RFRP is Request for Resolution Plan, which means as a resolution professional of a CD, I am inviting various people to come and kindly submit their resolution plans. On several attempts also, the resolution professional could not receive any plan that actually meets the criteria mentioned under section 30 subsection 2. Hence, the COC advised the RP, that is resolution professional, to apply for liquidation. However, remember one thing, that to decide whether to liquidate or not, it is only adjudicatory authority which is empowered. Hence, the adjudicatory authority will by an order ask for liquidation, but no other party can decide. They can only recommend, advise and make an application, but final order comes from NCLT. Until then, the liquidation cannot begin. So, the COC advised the resolution professional to make an application to NCLT seeking liquidation order. These are the 5 important facts. Then what are the legal issues involved in the proceedings? Number 1, whether the application for liquidation can be made where a resolution plan is already submitted, though it is not in compliance with the provisions of the section 30, but the plan is already submitted. While the plan being submitted, is it a fit case for liquidation, is a primary issue that the NCLT should observe now. Second, can the Honorable NCLT allow liquidation in such scenarios? Third, what would be the consequences of such order for liquidation? These are the 3 primary issues which had to be really observed by Supreme Court, by the NCLT, Ahmedabad Division Bench, and to decide what happened there. NCLT Ahmedabad has decided in the following manner and passed an order. The first point under the order said, it allowed the liquidation as the resolution plan did not meet the specified criteria. So remember, under section 33, the first circumstance that I said is whenever a resolution plan gets rejected owing to not meeting the criteria given in section 30 subsection 2, it's a very, very fit case for initiation of liquidation. Exactly that is what happened in Jigar Tarun Kumar Bhatt's case, where he was an RP of Eternal Motor Private Limited. The company got a resolution plan, but it was rejected on the grounds that it is not meeting the basic criteria given in section 30 subsection 2. Hence, the NCLT Ahmedabad said this is a fit case for liquidation. Number 2, the costs of liquidation shall be borne by the claimants according to the claim ratio. We are anyway going to deal with this matter in a while, but while we were actually covering the distribution of proceeds under IBC, we have seen waterfall mechanism where who gets the priority in terms of payment. Similarly, even in the case of a liquidation, we have a priority who gets a payment. But here the point is, in case the sale proceeds which are received from the sale of the assets are not enough to meet the costs of the liquidation, then the claimants shall provide for the cost of liquidation in the same ratio as they claim the proceeds. Very, very important part of the order. So this is an effect of liquidation order. Third, what happened? The third effect of the order rather is no cases can be instituted against the CD now because NCLT has passed an order for liquidation. And the fourth and the very important consequence of liquidation order that they clearly said is this liquidation order shall be an order or notice of discharge for all the employees, workmen and officers of the company. This is exactly what we understood from section 33. I hope you are clear about section 33 now. So to break it up and summarize again, section 33 provides for 2 things. Number 1, circumstances for initiation of liquidation. There are 4 circumstances that we have discussed. Number 2, it talks about The effects of passing of a liquidation order where no suits can be initiated against the CD, and it acts as a discharge order for all employees, workmen and officers of the company. Let's come to section 34 of the Act, which is the second section under the liquidation heading. Appointment of the liquidator and the fee. As we have understood already, the entire process of liquidation, as mentioned in IBC and also IBBI regulations, shall be carried out by a qualified insolvency professional who will be termed as liquidator as far as liquidation proceedings are concerned. He will be termed as a resolution professional in case of a CIRP. He will be termed as a liquidator in case of a liquidation. So how and who will appoint this liquidator? Can he be changed subsequently? And what is the component of fee to be paid to liquidator is what is enshrined in section 34 of the IBC. So the first point, section 34 empowers the National Company Law Tribunal, in our case we call them as adjudicatory authority, to appoint a liquidator after the commencement of liquidation process. So, the moment NCLT pronounces that there should be a liquidation, at that very moment NCLT will have to appoint a liquidator, because he is the one who is giving effect to the order, without which it cannot proceed forward. And remember one thing, as far as liquidator's appointment is concerned, there are two questions. Number one, can the existing RP continue to be a liquidator? Yes, existing RP can continue to be a liquidator unless and until he has done certain things which will disqualify him to be a liquidator, which we are going to deal with it shortly. Number two, can this liquidator be replaced eventually? And who can take a decision on appointment or replacement of a liquidator? Therefore, remember my friends, as far as appointment is concerned, it is a order of the NCLT which will decide who can be the liquidator. In majority cases, it is going to be RP who handled the insolvency will continue to be a liquidator. That's exactly what is written in the second point. The RP will continue to be a liquidator unless the order specifies otherwise. Why will they specify is what we're going to deal shortly. Then we come to section 34 subsection 4 of the IBC, which talks about replacement of an RP. Why and how and when the RP should be replaced. Let's think logically. Why should be the RP replaced? RP will be replaced because there is a certain issue with the RP, which can be a disciplinary matter or which can be a matter of non-performance or disqualification, right? So in those cases, if you decide to replace the RP, what is the procedure is what we are talking. The adjudicating authority, mark the word here, adjudicating authority shall by order replace the RP if. So, is it a discretionary power of the adjudicatory authority, or is it bound by the words of section 34? Mark my words, my friends, wherever the section is using the word shall, it is casting a certain responsibility or obligation on the adjudicating authority to actually do a certain thing. And what is it going to do? It's going to replace the RP. If the resolution plan submitted by the RP was rejected for failure to meet the requirements of section 30 subsection 2. Alright. So what we are saying is the resolution plan which was given by a resolution applicant was accepted by the RP. He had presented the same to COC without considering the fact that this resolution plan is completely missing the provisions of section 30 subsection 2, in which case it actually disqualifies the RP to be appointed as a liquidator. Very important aspect. Then let's come to second point. Second point says the board recommends the replacement of a RP to the adjudicating authority for reasons to be recorded in writing. Who's this board? This board here is Insolvency and Bankruptcy Board of India, the IBBI, might have some disciplinary issues against the RP, and hence it is recommending to AA that please replace this RP because of so and so reasons. Third case, the RP fails to submit his written consent under section 34 subsection 1. So remember, if I am an RP and I want to continue to be a liquidator in the liquidation process, then I must submit my consent to act as such within a stipulated time. Why is that required? Because most of the times RPs may not wish to continue to be a liquidator. So therefore, it is important for adjudicatory authority to check whether RP wants to continue as a liquidator or not. If the RP does not give the consent within the stipulated time, then also he will not be appointed as a liquidator. In fact, he will be replaced by another person who will act as a liquidator. So these are the primary reasons for which RP can be replaced. So we remember that until now we have covered section 33 and section 34. 33 talks about circumstances, 34 talks about appointment, replacement of liquidator. Now we are moving forward to section 35 of the Act, which provides for the powers and duties of the liquidator. Very important section. Most of the times we get confused as liquidators and resolution professionals as to whether we can do a certain thing or not. Provisions like this will bring in a clarity as to what are the limitations of his powers and what is the scope of actions of a liquidator. So first power of the liquidator is managing and selling the assets of the company. As we remember, the word liquidation itself would mean selling of the assets of the corporate debtor and receiving the sale proceeds, distribute those sale proceeds to the creditors of the company, and then finally go for dissolution of the company. This is what are the duties of the liquidator there. So firstly, liquidator will manage the assets and also sell them. What do you mean by managing the assets? See, until we sell the asset, let's say if I have a hotel property which is doing its business, and as a liquidator I have to sell this hotel property. But until it is sold, we have to maintain the property in a certain shape and manner. Only then it can be sold, so that managing and selling of the asset both will be part of the liquidator's powers. Second power, he can formulate and execute a liquidation plan as to how he is going to execute or how he is going to sell these assets and distribute the proceeds to the creditors. In this, it's very important to understand whether he is going to sell the assets one by one or whether he is going to sell the assets in a slump sale is the call to be taken by liquidator. That's why that's called a liquidation plan. Then after you make a plan, you really dispose of the company's assets. How do you dispose? It is always written in the IBBI regulations, but disposal is your power. Then paying the creditors in the order of the priority. The moment I talk about payment to the creditors, you must always remember section 53 of the Act that talks about the waterfall mechanism, how the proceeds should be distributed, who sits on priority, who comes next. Then Filing claims for debts owed to the company. This is very important. I am a corporate debtor myself. I owe money to someone, but I am also a creditor to someone. So someone else owes me money to the corporate debtor. So as a liquidator of this corporate debtor, it is important that he recovers the money that is owed to corporate debtor so that he can consolidate the entire proceeds and distribute to the creditors of the corporate debtor. Very, very important function. Then, in case anybody initiates a legal proceeding against the company or company initiates a legal proceedings, the liquidator will represent in all the proceedings. We remember section 33 bars this unless there is a leave from the adjudicatory authority. Lastly, we should report to the tribunal on what is the plan of action and how did he implement the plan of action, and now it's a fit case for dissolution. There are couple of case laws which gives us clarity on how section 35 operates. If we look at Mr. Kiran Shah, liquidator of ORG Informatics, it makes it clear, which was at NCLAT Delhi. NCLAT is an appellate tribunal, NCLT is adjudicatory authority, remember that. It is Punjab National Bank versus Kiran Shah. The facts of the case are, number one, COC made an application for removal of the RP after liquidation order is passed. Remember, the first question was who appoints the RP, who replaces the RP, right? Here the COC had made a decision that it wants to replace the RP, so it wants a new liquidator, and hence it's filed an application with the NCLT for appointing a liquidator who is not the same as RP. Second one, it has not shown any valid reason for such removal or replacement of the RP. If this is the application made by the COC or part of COC or one creditor, then what will be the issue? Issue is simple. Whether COC has such power to make an application where there is no specific legal provision that says that COC can make such application. Now there are two things. If there is no specific legal provision, we can call it as an implied power, or we can say that there is no such power at all. For a common man, for people who are learning law, or even, experts, sometimes it is very confusing. Therefore, it should be a matter to be decided by the adjudicatory authority once for all. So what happened? What did NCLAT say? NCLAT concluded that when there is no specific power given in the provisions of the Act, you cannot deem that power or you cannot presume that power, and hence the COC or any part of the COC creditor cannot make any application for replacement of the RP. Then the next case is SIDBI versus Tirupati Jute Industries Limited. This is again hovering around section 34 of the Act, which deals with appointment and qualification of liquidator. Adjudicating authority was NCLT Kolkata bench, and what are the facts? Facts are, number one, the resolution plan submitted by the applicant was subject to many conditions. It was not in conformity with the legal provisions given in section 30. Then the COC should not have approved such plan. However, the COC approved the plan. The RP should have advised the COC not to do that, and however, it skipped the attention of RP and COC, everybody, and finally it went into admission. Issues: whether the application for liquidation be allowed, where the RP be appointed as liquidator. Now here, remember, though the plan was approved by COC, eventually the plan was rejected by the NCLT because it did not meet the criteria mentioned in section 30 of the Act. In such case, is it a fit case to pass a liquidation order? Yes, section 33 of the Act says yes, it's a fit case to pass the liquidation order. But what is the context? Context is section 34 of the Act. Now it is asking whether RP can be appointed as liquidator. Now you can see the last line, which is a punch of the decision, which says that because the RP did not advise the COC about the resolution plan and the laxity of compliance with section 30, the RP now cannot be appointed as a liquidator because he missed to watch that very, very important condition. This acts as a disqualification to the RP and hence he cannot be appointed as a liquidator. So now we know what is section 33, we know what is section 34. There's another case, IFCI Limited versus BS Limited, again on the section 34 of the Act. This is NCLT Hyderabad. Issues involved are, can the COC make an application for replacement and removal of a liquidator? Remember, appointment was made by NCLT. But now if COC is not happy, can they make an application and ask NCLT to remove liquidator? A fantastic context and a wonderful decision given by NCLT Hyderabad. It says that section 34 does not deal with replacement or removal of the liquidator at the instance of creditors or claimants. So as creditor claimant, your role of dominance is substantial throughout CIRP. But the moment CIRP is done and we are talking about liquidation, the role of COC is minimal. You can just receive the sale proceeds distributed to you by the liquidator, but you cannot actually make any application to remove or replace the liquidator because this order was passed by NCLT. Fantastic context. One more on the similar lines. Here again, section 35 of the code, NCLT Hyderabad, issues involved are, if the consultations of the creditors have a binding effect on the liquidator or not. Now what we are saying is, if the liquidator consults the creditors and takes their opinion and the creditors give an opinion, is such opinion binding on the liquidator? Shall he follow that? Now NCLT gave a clear decision from Hyderabad which says in the second line of the conclusion, if you see, the proviso makes it amply clear that the consultation is not binding on the liquidator, hence he may or may not follow the opinion rendered by the COC when he consults the COC. Let's quickly wrap up our session. What is that we have discussed so far? We have discussed section 33, 34 and 35. 33 says how to initiate liquidation. There are 4 circumstances and then effects of liquidation is what we have completed. 34 talks about appointment, replacement of liquidator. We have very clearly understood that the liquidator can be RP. If RP was throughout CIRP, he can also continue to be a liquidator, but however, if he had not observed minor things like section 30 and had approved the resolution plan presented to COC, in that case he will be disqualified to act as liquidator. Then lastly, we have seen powers and duties of liquidator. We said that liquidator may consult the COC, but he need not be bound by the consultations with the COC. This brings us to the end of session 42.